Good morning. Thank you for joining us today. We are looking forward to having a conversation with you about litigation minefields and the importance of risk management. With our standard disclaimer.
Some bullet point questions.
My name is
Add them in the comment sections.
My name is Danielle Horowitz. I'm a life science specialist with Chubb, and I'll be the moderator of today's panel. I'd like to introduce our two panelists. Jeff Burris is the Vice President, General Counsel, and Chief Compliance Officer of Arbor Pharmaceuticals. Jeff has over 10 years of experience as a General Counsel and Chief Compliance Officer in life science companies, and over 20 years of legal experience. Jeff was previously the Vice President, General Counsel, and Chief Compliance Officer for Almira Sciences, a publicly traded pharmaceutical company. And before that, held the same position at CryoLife, a publicly traded biotechnology company. Prior to that, Jeff was in-house at Waste Management, focused on mergers and acquisitions, and was an associate in the corporate department of Arnall Golden Gregory LLP, an Atlanta-based firm. Tom Mazziotti is a partner in Hall Booth Smith's Atlanta office and an experienced trial lawyer who is the chair of the firm's Product Liability Practice Group. He concentrates his practice on a wide variety of product liability and healthcare matters involving complex, high damages claims. Tom has built a reputation for hard work, creative thinking, and aggressive defense of clients without sacrificing his professionalism. Over 20 years as a trial lawyer, Tom has tried numerous cases to verdict in both federal and state courts, and he has argued before the Georgia Supreme Court and the Georgia Court of Appeals. He has an active motions practice and has extensive experience mediating complex high exposure cases. I joined Chubb 6 years ago, and I'm a life science specialist. I have been an insurance underwriter for over 15 years. I started my career with the Zenith as a workers' compensation underwriter. After my time with the Zenith, I spent the following 7 years with Amerisure Mutual, managing a book of a business with a primary focus on construction and manufacturing risk. Here's our agenda for today. We're going to discuss the litigation environment, risk management, and what happens if you are sued. Product liability and the impact of social inflation. We see a lot of suits and claims, and we continue to see outsized verdicts. Typically, the actual damages like medical expense and loss of work are not that difficult to calculate. But what seems to happen is that juries want to send a message to companies once in a while. And while some companies should pay for injuries, awarding millions and millions of dollars in situations where the actual damages are relatively small or causation is questionable or based on junk science is not accomplishing anything, as those costs will ultimately be borne by society in the form of price increases or lack of product. Here's a quick recap of some high dollar verdicts in recent years. $4.69 billion verdict to a woman who contracted cancer from talcum powder, Kim versus Johnson & Johnson. $1 billion verdict to 6 plaintiffs in hip implant suit, Andrews versus DePuy, a J&J subsidiary. In 2018, there was a roundup verdict, $250 million in punitive damages, and $39 million in compensatory damages, which was lowered to $78 million. All were or will be reduced significantly, and a very small number of large cases skew perception of overall value. Here we see some data that shows the steady increase in verdicts and settlements, while the amount of cases has gone down. Verdicts are on the left and settlements are on the right, and both tell similar stories. One of the factors is that plaintiffs' attorneys are spending more time elephant hunting. Another factor in the product liability world is the amount of mass tort litigation like opioids and talc. It really does take a lot of plaintiffs' lawyers away from handling smaller cases. Next, we'll discuss litigation funding and attorney advertising. Increases in the funding and attorney advertising could have a significant impact on the number of filings of liability cases and the magnitude of awards. Tom, can you please discuss the litigation trends you see in the state of Georgia, including punitive damages and litigation funding?
Sure. Thanks. And good morning, everybody. I'm primarily practicing here in Georgia, though I'm keeping track of trends, obviously, across the country as it relates to products liability. And the first premise is product liability cases are expensive. I don't think that's a surprise for anybody. So the trend here is you've got a plaintiff lawyer, and what they tried to do is they first forum shop. And here in Georgia, we have become more of a hotbed of plaintiff. Before COVID, at least, we were having some significant plaintiff verdicts. So we're seeing more cases filed here in Georgia, and they're trying to find a way to get in Georgia, and certainly trying to find a way to get into certain counties. And the trend here, really, like DeKalb County is now becoming more and more of a preferred venue. So that's the first thing that you address, is you're going to find yourselves in some bad venues. What the other trend is, and I've had a couple cases literally in the last month, is they have added sales reps or any individual they can find under a very tenuous, and a lot of times there's really no merit to their claim, in order to defeat diversity to get these cases up to federal court. And it's called fraudulent joinder. And what we do is we remove the case from state court to the applicable district court here in Georgia. And that's just a more preferable venue to be in anyway. Typically, you have a better jury pool to select from. And the judges are going to be more experienced with product liability lawsuits and more experienced with Daubert and how to deal with expert discovery, expert challenges, etc. So what the trend's going to be, we'll see, and we have seen, is they're trying to find these, file these cases in Georgia and keep them here in Georgia. We also see that they're trying to make it a mass tort, meaning it's not a one-off case because they want more bang for their buck. And that gets into this litigation funding issue that we see on the screen here. What's happening now is there's these third-party litigation funding companies that really, in fact, go up to Wall Street, such as hedge funds and the like, and they actually fund the litigation for plaintiffs' lawyers. Interestingly, it started out in commercial litigation. Now it's morphed into personal injury litigation, and certainly in product liability litigation. What they do is, for a certain percentage of the settlement or the verdict, in addition to getting their funds reimbursed, they will front the costs. And now we're starting to see, in certain circumstances, where there's no risk on the part of the attorney, and we'll see the ethics of all that in years to come. But right now, we've got plaintiffs' lawyers who are getting funding, not coming out of pocket, and getting funded by these big Wall Street companies in order to bring these expensive product liability lawsuits. We're also seeing more collaboration among plaintiff lawyers. What we'll see is there'll be a case filed in Georgia, and they'll be talking to lawyers who have filed a similar case in Alabama. And a lot of times they'll even want to be able to report things to government agencies on their own behalf. And what we try to do, of course, with a protective order, is to prevent this collaboration among plaintiff lawyers nationwide, so that if you produce documents here in Georgia, they're not shared with a lawyer who is suing the same product liability company out in Seattle or elsewhere. Also, plaintiffs should not be reporting anything to government agencies outside of what, perhaps they're making a report on behalf of their own client in an adverse event report or the like. The other thing to mention here, or there's two more things to mention. Here in Georgia, punitive damages typically have a cap of $250,000 unless in certain circumstances where there's a specific intent to harm, fraud, etc. That cap, however, does not apply to product liability or product manufacturers. So that's another carrot for plaintiff lawyers to come after product manufacturers. It expands the scope of discovery, makes life very difficult and very expensive. And then the last thing I wanted to touch upon as far as trends is, in the last week and a half, the Supreme Court of Georgia came down with a very favorable opinion that allows apportionment of damages in product liability lawsuits. And to cut to the chase, so to speak, Typically in a product liability lawsuit, the claims involve strict liability, negligence, failure to warn, etc. Well, in strict liability theories of recovery, traditionally, a product manufacturer could not use as a defense comparative or contributory negligence. And that what we would see is on the eve of trial, they would dismiss negligence theories and stick with their strict liability theories and would restrict the evidence. And there could be no evidence about the plaintiff's user error, for example. However, now that the Georgia legislature passed a statute on apportionment of damages, which allows the jury to apportion damages as to the parties and even non-parties as to the degree of fault, product manufacturers now can make that argument that user error should be taken into account and should be, a plaintiff should be apportioned a certain level of fault and reduce damages. And so that's really significant. And it has just come out. It started off, obviously, trial court, went to the Georgia Court of Appeals, and has worked its way all the way to the Supreme Court of Georgia, who again just rendered this result, which again is a very, very positive thing for product liability manufacturers here in Georgia. Danielle, that's about it.
Thank you, Tom.
For this point.
Okay, great. Thank you very much. So Tom mentioned this briefly in his discussion. So what are they suing for? And there are some different theories of product liability. So like Tom mentioned, there's negligence, strict product liability. So the elements of negligence are company owes a duty, company breached that duty, and that breach caused injury or harm to the person. In strict product liability, the duty and breach of duty are already presumed. The plaintiff only needs to prove causation and harm. There's also warranty, but that doesn't factor in very significantly and is not covered by a product liability policy. Some medical devices, like monitoring devices or breast implants, do contain warranties. So if the device has a problem, that's covered. You get the device fixed or a new device. Easier to think about in examples of monitoring equipment, but tougher to think about with breast implants. The minute the claimant wants any compensation for pain and suffering or anything beyond getting a new breast implant or a repair, it comes out of the warranty program and turns into a product liability claim. Jeff, can you please discuss the importance of internal processes for communicating adverse events to in-house counsel and appropriate parties? Additionally, why is it important to build relationships with your risk management partners, such as your broker, carrier, and defense attorney prior to a suit being filed?
Sure, thanks, Danielle. And as Tom said, good morning to everyone. I'm happy to be part of this and hope I get a chance to meet most of you all at this Georgia Bio. So, one of the big important things as an in-house attorney is trying to understand your company's products, right? You've got to understand what adverse events are likely. You need to understand, if you have a significant number of products, what the clinical trial showed from an adverse event. What do you see from an adverse event? Understanding what's normal versus what may be extraordinary, I think, is very important. And you need to understand that yourself. You also need to understand how your company's quality system works, right? How is its complaint handling? How are your adverse event reporting mechanisms working? Who are the people involved in that process, right? How good are they at dealing with issues? I mean, sometimes you may receive a complaint from an individual that has been harmed. Do they have the fortitude and compassion to be able to take down information in a way that doesn't create additional problems with that individual who may be harmed or injured, or with their loved ones that have communicated with you? How are those teams reporting that information internally? How have they been trained? The lawyer lots of times doesn't get notice of what actually happens until down the road. And so how do you work with them on when should they let you know? What information should they give you? I know one of the companies I worked at, someone in the adverse event group, I got to have a very good relationship with him because periodically he would have to call and tell me that there was a problem with one of the products that we had. And I had to get to know him and understand what the process was, because we would have communications, not all the time, but probably once every 6 months I would get one of those calls from him. I used to joke with him that I needed to give him some type of joke book, so that knock book, so that when he would call me, I wouldn't be so nervous that there was an issue associated with someone being injured. How do your third parties manage? Lots of times for AE reporting, it's not necessarily someone in the company, but you have a third party that's helping you with that process, right? Are you, as part of the legal team, are you sitting in on the quality management meetings that the company is having on a quarterly, monthly, or annual basis? Are you seeing what those trends are? Sometimes trends can show that there's a problem that maybe you didn't ever know before. If you don't have those relationships internally, then it's very difficult to be able to do your job, to see what may be coming, because, you know, as an attorney, you really need to be able to advise your clients before they're in that circumstance where they have litigation. And I think, Danielle, you asked the second part of this, which I think is also incredibly important. You know, why is it important to build relationships with the risk management partners? I think Tom just really kind of went through what's going on. There can be changes in the law that have occurred in the last 6 months or in the last week, as he mentioned, with apportionment. If you don't have a good relationship with counsel that you may be using, with your broker, with the insurance carrier that's providing you the product liability insurance, you may have a big issue, especially if all of a sudden there's a significant amount. You get a complaint, you get a legal complaint, and you're behind the 8 ball. If you don't have those relationships, it's going to be much more difficult for you to be able to do what you need to do internally and then manage externally. If you've got really good outside counsel that you're comfortable with, and your broker can help you with those processes and help you with the notices that you need to give to your carrier, and you've got a good relationship with your carrier, then you can really more focus on dealing with the internal issues. You know, you may have a board or a CEO or someone in the C-suite that's very nervous about this impact. You know, if you're in a public company, you may have an obligation to disclose something if you know, at some point down the road, once you get through discovery. So if you don't have those relationships, what do you do that first time, right? And then the other part of this, and this gets back to, you know, how do you manage the external so that you can manage the internal? You know, if you're in-house counsel, one of the benefits that you can have is that you can potentially attach privilege to whatever it is that you're doing. But if you're only doing an investigation and you haven't notified your broker and you haven't put a legal hold in place, then it's going to be really hard for you to argue that you've got privilege associated with what you're doing. You may still be able to do that, but you need to understand what that is. And having outside counsel involved and helping you with that process can help you be able to claim privilege, which may be very important to get to resolution on what actually happened as it relates to, was there a manufacturing issue? Is this just a one-off scenario? Are there other issues that may be arising? You know, you may have a situation where you have a recall all of a sudden caused by someone that's communicated a complaint. So you need to understand all those things. You need to understand your quality system. You need to be comfortable and have relationships with people in those positions. And then you need to have good relationships with outside counsel. You need to have a good relationship with your broker and your carriers. And that's it, Danielle.
Thanks, Jeff. Tom, is there anything that you would like to add?
Simply, you know, those are excellent points by Jeff. I can tell you, the most successful cases that I've had is when in-house has been involved and they know the business so well. So whenever it just makes it very easy for me to do my job. Whenever I need a document, they know who to talk to. If there's an issue, they know where to chase down things. So you know, I think that's very important to get to know your people and get to know your business. You know, one thing I think Jeff mentioned about legal holds and litigation holds, keep in mind, you know, years ago there was an event, I'm actually with the client, and there's a debate about whether a litigation hold should be sent out. And nobody likes to send these because it's really a distraction. You know, depending on how broad the litigation hold has to be, it can really cause significant problems or logistical problems. And during this debate, I simply asked, the fact that I'm here, doesn't that mean you're contemplating litigation?
Right.
And like Jeff said, everybody nodded like, well, doesn't that really answer our question?
Right.
I hate to say it, we've got to do a legal hold. And again, working with someone like Jeff who knows the business, you know, and this has happened to me. I send, because we lawyers like to send an overbroad litigation hold because we want to make sure we capture anything and everything. And so I send this and I get a call from the in-house counsel saying, Tom, you realize you're going to shut down our email system, right? Like, well, let's talk this through. If you've got a good knowledge of your business, you can really help us tailor a litigation hold that meets the requirements. It doesn't have to, if we end up in litigation and we don't have a document and you followed your retention policies and it just happened to be deleted, et cetera, but the litigation hold was crafted correctly, it's going to be okay. It's where you don't even make the effort to do a legal hold. And then as far as Jeff, the point about if you're involved early enough, if there's indemnity type of provisions where it could be a vendor that's been involved, you get them involved early and they may, assist in some subsidizing some of the cost it takes to do some of these issues. So, also keep that in mind as well. Thanks, Danielle.
Great, thank you. One item I failed to mention at the beginning of the presentation is that if the audience has any questions, please feel free to chat them in. We are monitoring the chat, so feel free to ask us questions as we go along. Okay, next we're going to talk about the causes of action in product liability. The first is design defect, then there's also manufacturing defect and failure to warn. So design defect. Sometimes a product recall leads to design defect litigation. For example, a medical device company makes knee implants. They start getting some complaints from the surgeons that the kneecap is loosening after surgery. People start making some claims. The medical device company investigated and concluded that the knee implant was made with shallower dimples on the surface area than it should have, so it doesn't adhere that well. They meet with the FDA and end up recalling the product. They design it with deeper dimples and it works much better. No loosening or adherence issues. Tom, a product recall can lead to design defect litigation. Can you please discuss the importance of record keeping, especially when it comes to design controls?
Sure. Again, this goes to really to the litigation hold, and there's always a balancing act as to whether there are sufficient number of reports to do a recall. And it's an art, not a science, as to when that will be impacted. The gist, however, is you want to make sure that you get control over the documents that are going to be relevant. If it ends up in litigation, you want to be involved in how they are phrased and the language that's being used, obviously. And I think we all know, there's no commentary that needs to be in there. It's facts, just the facts, and an objective language on these things. So that's the first thing. As I mentioned, you want to get this litigation hold in place, and then you want to start thinking, and I always like to think in buckets. And you've got a bucket about design documents, you got a bucket on manufacturing documents, you got a bucket on quality control, perhaps reporting. And so that's the first thing. I like to think in those categories. What documents, depending on the industry you are in, whether it's drug, device, you're going to have different things. You're going to have reporting documents to government agencies, and government agencies are going to want to have or are going to want to receive certain documents, especially in a recall. You're going to have to know the lots and the batch that's involved, and it's going to be important as not just for litigation, but for purposes of reporting to the FDA or any other government agencies that may become involved as to what you've done, and you want to be proactive about it. And there's going to be considerations as to whether there's sufficient information there for a recall. And if you don't have the documents and you've got good control of those documents, then that's going to probably lead into one of these government agencies insisting on some type of involuntary recall.
Thank you. Can you also speak to the differences in the FDA classification for medical devices and how this relates to potential defenses that are available?
Sure. In medical device litigation, you've got basically three categories or three classes of documents. They range class 1, class 2, and class 3. And class 1 and class 2 are, and I'll lump those together, but they generally pose a lesser risk than class 3 devices. Class 3 devices have the highest risk, Basically, they are the life-saving devices or technology out there, and there's been a policy in place that we want to encourage medical device manufacturers to come out with these life-saving devices, such as, pacemakers, prosthetic heart valves, balloon catheters, and the like, in order to promote these types of innovation. We also want to protect so that they don't open themselves up to liability. So Class 3 medical devices have to go through a very rigorous, stringent process in order to get FDA approval. And under the Medical Device Act, they spend approximately 1,200 hours, evaluating this pre-market approval process to determine whether or not the safety outweighs the risks involved with this device. And in return, once you get this pre-market approval, you have certain defenses, and it's called preemption. And it's a doctrine that we could spend hours discussing, but the gist of it is this. If, in fact, a product manufacturer or a medical device company follows the design process and the manufacturing process that has been approved during the pre-market approval process, has done the follow-up, followed their warnings, all of this that's been blessed, so to speak, by the FDA, then the plaintiff cannot sue for a design, manufacturing defect, a failure to warn, because what they are basically arguing is they're second guessing the FDA. They're saying our design is better than what the FDA approved. Our warnings are better than what the FDA approved, and you can't do that. It's been preempted under federal law, which indicates that once the FDA approves a design, a manufacturing process, a warning or instruction, the company cannot vary from that. They cannot change the design without the FDA's approval. They cannot change the manufacturing process without the FDA approval. It is a significantly regulated device. So what happens in that circumstance is any of these lawsuits that get filed, and I've got a couple pending right now, first thing we do is we file a motion to dismiss based on preemption. Another good reason to be in federal court, by the way. And so what the plaintiffs have to show is that somehow the medical device manufacturer did not follow what the FDA approved. They varied their design or the manufacturing process, or I think more frequently what happens is their warnings, they have added or changed their warning in some way that is substantive and did not notify the FDA. And that's what they've got to show, that the device company did something that was separate from what the FDA approved. This again does not apply to Class 1 and Class 2 devices such as walkers, bandages, things like that. This defense only applies in this subset of Class 3 medical devices that has to go through this very rigorous process to get approval.
Thank you, Tom. Jeff, I'd like to get your perspective on what life science companies can do to help mitigate and protect themselves from design defect allegations.
Sure. So I touched on this before, but you want to make sure that your quality system is working and that you're involved and understand what those trends are. And then more importantly, for many companies, they're not really manufacturing for themselves. At Arbor, we are virtual from a manufacturing standpoint. So what are the reputations of the CMOs that you're using? What are the reputations of the CDMOs, the designers, the manufacturers that you're using? What kind of diligence is being done with them? Are they in this space? Have they been in this space for a long time? Have they had a lot of litigation associated with it? Unfortunately, lots of times the lawyer's not involved in the manufacturing decisions about where to go. It's based on who might have that expertise. And you may only get involved at the end or at a term sheet or when you're negotiating the agreement. And Tom can speak to this too, but lots of times you have a lot of pushback from manufacturers when you look at contractual protections that you might have, right? So maybe the issue is something associated with something the CDMO did. They don't want that liability. They just want their liability to be capped at whatever you've paid them if you're, or they may want that to be even less. And so how strong are your teams in making sure that the design has been done the right way? How strong are they in selecting those companies that you're working with? And then, if there is an issue, are you involved in a decision for product recall, right? Are you involved in the decisions that are happening at the manufacturer? Because the manufacturer may have its own obligations to the FDA while you have your own obligations. Those two obligations lots of times overlap, but sometimes they're different. And if it's, you're using a large manufacturing facility that is owned by a big company, they may have a different viewpoint on how they want to deal with what you may think is a small issue. They may be concerned that this impacts every aspect of their manufacturing for all of their lines of business, not just yours. And so you may have a yin and yang or push and pull associated with how do you deal with that. And making sure that your management team understands that, yes, this may be the lowest cost provider, but that may not be the best thing for the company, because if we were to get hit with a design defect or a large number of lawsuits or a recall, whether voluntary or involuntary, you have a big issue potentially associated with it. And I think the other part of that is, making sure that your management team understands that if the quality team is telling them that they need to do a recall, they need to do a recall. It's really not, yes, you want your CEO to be involved in that decision, but in the end, if your quality team is telling you there should be a recall, then that's really what you should do. You can ask questions, you can challenge as to why, but that is ultimately something that you should follow through on what the quality team is doing, so that you understand because if you don't, and you've got that discrepancy in that issue, it's likely to come out in your litigation. Even though you may try to put privilege around it, there may be a question asked of somebody in the quality team, did you recommend a recall? So just keep all of that in mind. And again, it's good to have relationships, and it's good to make sure that no one's making a final decision until you've gone through all that information internally.
Jeff, you brought up something that I thought was a great point, and I've had to tackle this at some point in my career, and that is when you're using, an outside manufacturer, there are concerns with proprietary, commercially sensitive information. And fortunately, I don't deal with this on a day in and day out basis, but those that are in-house or part of the company, there is a tension sometimes because they may view you as a competitor, and they may put up roadblocks with your inspection process. And it's easy for me to say, well, you got to do it and just do it. And I know that's easier said than done, but keep that in mind. There are real life, concerns that probably should be addressed on the front end about the inspection process, so that when something happens, you can go and inspect, and that you're not viewed as the competitor, and you're going to be exposed to proprietary information, and they don't want to share anything with you. Because if you get sued down the road, the allegations are you've got a rogue vendor and you're not doing your job by going and inspecting. Whether that's true or not, again, that's obviously going to be an argument, but that's what the plaintiff's going to argue. You did not exercise sufficient oversight. You had the contractual right to oversee that, but you didn't do it. So keep that in mind. And then, of course, the litigation insurance issues. And that is, having your vendor have insurance as well, and whether you're an additional insured and so forth. And there will be an argument about that. I guarantee you, whose issue is it? Is it the manufacturer or the vendor who should be covering the claim? But yet, there's insurance out there that covers these things. There's recall insurance. I know some of this is expensive, but to the extent you have leverage in making sure that the vendor has insurance in place, that you confirm it, not just with a certificate, perhaps even seeing a declarations page, so that if it does hit the fan, that's not the time that you want to find out that they did not have the appropriate insurance in place, or that you were not an additional insured.
Yeah, I think one other thing, Tom, too, is many times in the pharmaceutical space and in the medical device space, your manufacturer may be putting things together or doing most of the manufacturing, but in the drug space, your API, your active pharmaceutical ingredient, may not be manufactured, and probably isn't by whoever the group that's putting it all together in the end. Where is that coming from? What's the reputation associated with that? For some API, there may not be that many places around the world that are manufacturing that API. So what's their reputation? And then who's in charge of the quality inspections associated with that API, right? Is it the manufacturer that you have, or are you stepping in and doing that? Those are all the things you need to consider and think about. And then if you are, or if your manufacturer is, what are their indemnification as it relates to the API? Because you can have, and I think we'll talk about this a little bit later on, an issue with your API that doesn't necessarily show up at the manufacturers, your contract manufacturers, and understanding that's very important.
Great, thank you both. All right, so we are going to jump into manufacturing defect, which we've touched on a bit with the design defect. So here the design was correct, but it was manufactured incorrectly. This is the main concern contract manufacturers have. Usually products are made correctly, there are significant quality controls in place, and normally these errors are caught. In some cases, a lot of goods or batches made incorrectly and gets out. That recall will be made for the exact lot or batch, as we've discussed. Jeff and Tom, this is a question for both of you. We can use the manufacturing defect incident that has been highly publicized regarding nitrosamines. What lessons has the industry learned from this incident?
Tom, do you want to take this first, or would you like me to go first?
I think you touched on a little bit. I'll just kind of piggyback, and then you can add on. But obviously, this is a fairly new, FDA guidance that's come out, I think, in late September about, the levels and nitrosamines are in everything, and so to that extent, the lesson that I would say is, as Jeff just mentioned, making sure that on the front end, where these are coming from, where, these APIs that go into your ultimate drug. But, the FDA, the way I believe it's written right now is if there are certain levels, and if you've got if it's over that level, then you need to notify the FDA, and you're going to have to do a recall. And nobody wants to do a recall. It's expensive. If they find more than one, then you've got to consult with the FDA. From my perspective in litigation right now, it's a bit early to give you what's happening out there, but it goes back to that pre-litigation risk management, and just referring back to that and making sure that you've got the documents and ready to be shared with the government if need be. Jeff?
Yeah, I think as we talked about, you may have your manufacturing facility in North America or Europe that's really doing the contract manufacturing for you, but where are they getting their API from, right? And understanding that, and understanding the full supply chain, where they're getting their excipients from a drug. You not only have your API, but you may have excipients that are not necessarily for the active, but are very important for how you actually ultimately manufacture the product. And you may have some same things in a medical device area. And lots of times, right, if you think about the world where there are cheaper places to manufacture, lots of times people think of China or India. Well, there are costs potentially associated with it that come out, maybe not immediately and maybe not for a while. And so understanding who have you selected as your manufacturer, was it just based on lowest cost, or was quality involved in that decision? That's very important, right? Because you've got to balance those two things, because if you don't have good manufacturing, you can have a significant issue. And then what are they doing from a quality system standpoint, right? How are they looking? How is your quality system looking at its vendors, and how are they doing their inspections? Are your audits desktop? Are they, in other words, virtual, where they're just getting information? Are they doing physical inspections? How are they doing those physical inspections, right? In the world of COVID, sometimes it's been a little bit easier. If you're in North America, manufacturing may not be as big a problem, but that is another issue, right? And there's been some discussion in the United States about, we don't have a lot of manufacturing now for a lot of these things. How do we get that manufacturing back to the United States? Because there's concerns, not just because of this manufacturing defect, but also because what happens if there's a supply chain interruption, and that can play in. So if you can think about the manufacturing and be able to discuss it with your management team from a risk perspective, supply chain, manufacturing issues, how are we managing and dealing with the quality costs of doing inspections, you may have a better way of getting them to buy into, maybe we don't need to pick that API manufacturer in India versus the one in France, because the one in France may have a little bit more expensive, but when you actually look at the overall cost, it's not that much different. So I think it's really important to understand what's going on and that you're involved in those manufacturing decisions and discussions that are occurring, and making yourself a valuable partner internally to your management team.
Thank you both. Okay, now we'll move on to failure to warn. Okay, so believe it or not, failure to warn is normally the cause of action that we are defending. The drug company actually has a duty to warn the prescribing physicians for prescription drugs. If the company is aware of side effects or interactions with other drugs, they need to put that in the label. Sometimes we see claims where the person took a drug that actually had the older label, and then the label was updated to include that it is counterindicated with another drug or class of drugs like SSRIs. The same failure to warn argument is made in clinical trials litigation. The informed consent is a document that lays out the information about the trial as well as the risks. But since it's a trial, not all risks are known. When underwriting, we look to see if the ICF contains some catch-all language like not all risks are known and unforeseen serious adverse events could occur, including death. For a dandruff shampoo study, we wouldn't look for that. But for a monoclonal antibody for cancer, we would. And then there's also direct-to-consumer advertising may actually erode some of the protections drug companies have called the learned intermediary doctrine, which I'm going to ask Tom to go into a little bit further in a minute. The plaintiff lawyer will argue that the commercial caused his client to want the product, and warnings on the label were superseded by the images of a happy 7-year-old guy riding his bike up the side of a mountain, as healthy as can be, but taking a pretty heavy-duty rheumatoid arthritis drug. So far, we have not seen too much erosion of this defense, but it can play well in front of a jury. From an underwriting perspective, we spend a lot of time reading labels and making sure that the warnings are clear. For over-the-counter drugs, the duty flows to the consumer since the prescribing physician is not necessary. Tom, can you discuss the role of the learned intermediary in failure to warn allegations?
Sure. Basically, in a failure to warn claim, just to I guess simplify what the allegations are, it's a failure to adequately warn of the risks or known risks associated with a drug or a device. And in this area, your best friend is the treating physician. And of course, the direct-to-consumer advertising, it makes things more difficult because now everybody is an expert based on what they see on TV, and they go in and presumably will ask questions about this particular drug or a device. But the issue is, the duty to warn about these known risks or potential risks associated with your drug or device. And in the learned intermediary doctrine, the bottom line is, who does the duty go to? Does it go to the consumer? No, it goes actually to the treating physician. And so the question is, does the treating physician have appropriate information in order to make a medical diagnosis, taking into account the specific individual the physician is seeing, as well as the information related to the drug or the device? And so in this litigation, what the plaintiff has to do is show that somehow an additional information or a different warning would have changed the physician's mind on whether to prescribe this drug or device or to implant a device. And it's important because, at least here in Georgia, back in February of this year, a district court here in Georgia dismissed a case because there was no treating physician testimony as to whether he would or would not have prescribed a drug or device. And it was the May versus Evicon case, if you want to look that up. But the bottom line is, what typically happens, the treating physician is going to be deposed. And once the treating physician is deposed, there will be hypotheticals. Had you known this, would you have still prescribed this? Had the company shared this with you, would you have treated this any differently? So the learned intermediary doctrine is a very good defense for a drug and device manufacturer, as long as the treating physician doesn't come in and say, sure, had I known these things, I would have done differently. Usually they don't. And usually these cases are, unfortunately, you've got the treating physician who is a co-defendant. So you coordinate with the co-defendant's lawyers. Unfortunately, here in Georgia, defense lawyers try to cooperate with each other as much as we can, and not do the plaintiff's job. Sometimes you can't help but step on each other's toes, but more often than not, we try to take out the impact of getting unfavorable testimony that could really hurt the co-defendant. Other jurisdictions in other states, it doesn't work quite as well. But the bottom line is, whether the treating physician is a co-defendant or whether the treating physician is a non-party, you want to make sure that you get favorable testimony that says, I had all the information I needed in order to prescribe or implant, and I would not have changed my mind with additional information with different information. If that holds true, the court will dismiss a failure to warn claim.
Great. Thank you, Tom. We're going to jump ahead to a topic about off-label promotion. So I wanted to ask you, Jeff, from a risk management standpoint, can you please discuss why it's important for the compliance department and or legal department to understand how products are being promoted? What sort of training and processes would you suggest for management to consider for their sales force? And what about when the sales force is a third party?
Sure. Yeah, I think first, Tom was talking about the learned intermediary. You may have a doctor that didn't necessarily know, or the question may be, had you known this? If you have a rep that has told the doctor something that is inconsistent with your labeling, or they've downplayed a black box warning, you have a problem, because now all of a sudden you don't have necessarily, you've created space between you and that doctor. So it's really important that you understand what your reps are promoting and how they're promoting, and that they understand they need to stay in the four corners of the promotional pieces that have been approved. So from a training perspective, and pharmaceutical companies and medical device companies do this, you train your reps, you walk them through the compliance risk, you make sure they understand they cannot promote off-label, that if there is an off-label question that is asked, it doesn't get answered by them, that it goes into a specific mechanism that's addressed through a compliant way. You've got to train on the on-label. You've got to make sure that they understand that they have to give fair and balance, that when you have a promotional piece, there's a reason why, if it's a black box warning drug, that the black box warning is so prominent, that there's a reason why they have to put in, if they're going to make a claim, that they have to explain why there's other balancing information associated with it. I try to impress on the reps when I'm dealing with them that if they may feel like they have a great relationship with the doctor, but in the event something goes wrong, a doctor, if they have done something incorrectly, a doctor may throw them under the bus, because it's the doctor's practice, it's the doctor's livelihood that may be at stake here. And so they need to understand that they need to do things the right way, because then it's very easy to get a very cooperative doctor, because the doctor understands they promoted it the appropriate way. From one of the issues, right, is you can't go out with every rep that you have, especially lots of times if it's a contract sales organization, which is one of the questions you were asking me, Daniel. So how do you know that? Well, I think one way is you do ride-alongs, right? I've done ride-alongs with reps. You actually go with them to visit the doctors. You see how they're using their promotional pieces. It's helpful to me to do that, because I sit on promotional review committees, or what some people may call medical legal review committees, where you actually review those promotional materials. Understanding the challenges and the questions they're getting asked from doctors when you're going out and doing those ride-alongs is helpful. I don't think reps really like to have compliance with them when they go out and do those, but every company does that. And from a contract sales organization, there are actually groups out there now that will do their former contract sales reps or their sales reps that now will do compliance ride-alongs for you. So there are third parties that can do that for you to help multiply. I'm the solo attorney in my company, and we have 200 reps, so I can't do all those ride-alongs, but there is a way to use systems out there and to use companies out there that do those ride-alongs. You also need to speak about issues of compliance constantly, right? A compliant culture is really important, and that starts at the top, and it's something that you should stress with your reps constantly. I try to go to the sales meetings. We try to go to some of the quarterly meetings that they may have, so the reps get to know you and you get to understand them. Having, a hotline that a rep can report if something's being told them to do something different, right? Auditing emails, auditing other things, your Viva or whatever your sales organization is using to manage their sales reps, their call notes. Those are all important. If you don't do those things, you can create a situation where you may have the drug that was designed appropriately, where there's no problems, but you have a rep that's done it, has promoted it off label. And that can create issues that you were unaware of and can create massive problems for you.
Thank you so much, Jeff. We're out of time. And if there are any questions, I believe you can enter them in the Summit platform in the chat feature there, and they'll be saved for us to view and respond to. Thank you so much, Jeff and Tom, for participating in the panel discussion today. Thank you all for being our audience, and have a great summit. Thank you.
Thanks, Danielle.
Thank you.